Good afternoon. I've heard the discussion at the conference has been very interesting, and I can tell it was a little difficult to interrupt the conversation just now. So obviously, there's been a lot of food for thought already. It's my pleasure to introduce our keynote speaker today, the Honorable T. John Ward, retired district judge for the United States District Court for the Eastern District of Texas. Judge Ward received his bachelor's degree in chemistry from Texas Tech and a JD from Baylor University. After getting his law degree, Judge Ward spent 31 years in private practice as a malpractice and products liability lawyer. In 1999, he was appointed to his position as U.S. District Judge by President William Clinton. While serving as a federal judge, he presided over 150 jury trials and managed a diverse intellectual property heavy docket, resulting in the final disposition of over 3,000 cases before retiring in October of 2011. He is a life fellow of the Texas Bar Foundation and served as a member of the Judicial Conference Committee on Court Administration and Court Management from 2003 to 2009. He is a longtime fellow of the American College of Trial Lawyers and was judicial fellow during his years on the bench. He is an advocate of the American Board of Trial Advocates and served on the Board of Governors of the Fifth Circuit Bar Association from 1987 to 1991, and again from 1996 to 1999. He was named the 2004 Baylor Lawyer of the Year by Baylor University School of Law. In 2006, the American Inns of Court, in cooperation with the members of the local bar, chartered the Honorable T. John Ward American Inn of Court for East Texas. In 2009, the Texas chapters of the American Board of Trial Advocates named Judge Ward Trial Judge of the Year. He was profiled in the fall 2010 Intellectual Property Supplement of the American Lawyer magazine and was selected as one of the top 25 most influential people in IP. Please join me in welcoming our keynote speaker, Judge T. John Ward.
Well, I first need to say that for those of you that were at the seminar part of the program where they had the intellectual part, this will not be intellectual. I got to say about those overly kind remarks from the panel that made tribute to me. You have caused great conflict in my brain, Judge Everingham, and you know why. Because as he knows, I have what you call I call it the H.L. Mencken filter that I have worked out over the years. For those who do not know who H.L. Mencken was, he was the rather colorful editor of the Baltimore Sun in the first half of the 20th century. And he had some rather pithy, insightful quotes. Some people referred to him as a sage of Baltimore. And the one that's back there now, just going off in my brain, is what he said when he says, nothing is oftentimes a good thing to do and almost always a good thing to say. So I really don't see how I could be better off just to say thank you very much. And I was humbled by those remarks and sit back down because there's no way I can live up to that. But I know that all of you that heard those remarks will know that they came from experienced trial lawyers, so you give them such credibility as you think they deserve. And Professor Wynn, given your propensity for bragging on me too much, I'd say, have you ever considered going into trial practice? I'm just joking. You make such a great contribution to the development of intellectual property law, but I do need to say this, and I'm very serious. I'm speaking on behalf of myself and all of my former colleagues on the Eastern District of Texas. I want to thank you and the SMU School of Law for being such supporters of the Eastern District. It was greatly appreciated. So I really am sincere in telling you that because with us, it sort of leads into what I have entitled this talk, that there is always hope. When you see in light of what some other commentaries were being made about the Eastern District of Texas, and then you have some very positive one, I say there's always hope. So thank you. When she called and asked me to give this talk, she did not tell me about the tribute. I learned that when she sent me electronically the announcement of the program. And so I might have thought of another conflict that I had before. But because I don't, over the 12 years I was on the bench, I don't believe I ever gave any speeches other than eulogies. And I always tried to just say I'd be on judicial panels. And I did travel all over the country, as Gilda said I did, trying to talk to lawyers. And I always tried to get Judge Barbara Lynn to be on my panel when I could. Now, I understand some of her staff members are here today, so you make sure and tell her that I said this about her. The reason I always tried to get Judge Lynn on the panel was if I didn't know the answer, she knew it, or she was real good at winging it, and she raised the judicial IQ to an acceptable average. Now, I want to ask you a question. How many of the lawyers and students here have been practicing law 30 years or less? Could I have a show of hands? 30 years or less? Well, I want to tell you, after I'd been practicing in my 31st year, and I got a phone call from a lawyer out in San Francisco, and he employed me as local counsel in the Texas Instruments versus Hyundai case. And so little did I know that there was, at that time, litigation pending in 6 European countries and Japan. And we had 2 districts in the United States, and all 14 cases ended up in Marshall. So we had our first phone conference. And I had all these lawyers, and they were asking me, you know, they said, well, how does Judge Hartfield handle a Markman hearing? I said, well, I really don't know if Judge Hartfield's tried any patent cases, but I'll check on that and find out. Well, does Judge Hartfield allow you to use experts in a Markman hearing? Well, I really don't know about that. Well, does Judge Hartfield have any rules that govern a Markman hearing? Well, I'll check on that. Well, I just kept writing these questions, and finally got off the phone conference. So I picked up the phone. I called my friend Sam Baxter over at McCool Smith. Sam, this is John. He says, yeah, what is it? What can I do for you? Didn't you handle a patent case a couple of years ago? Yes. I said, what in the hell is a Markman? So there's always hope. There's always hope, folks. On a little more serious note, this March 27th of this year, I was at dinner in Washington, D.C., where Congressman Lamar Smith and from San Antonio, Senator Patrick Leahy from Vermont were being honored for their work in the passage of the America Invents Act. Now, Senator Leahy was not present, but his staff was, and Congressman Smith was accepted the award that was being given, and he made some remarks. And one of the things he said that that caught my attention was how he mentioned the fact that the AIA, the American Invents Act, was one of 2 major pieces of legislation that were able to be passed in the year 2011 with bipartisan support. As I was listening to those remarks, Chief Judge, for the first time I found out that Chief Judge Rader expected me to make some remarks when he left the podium. So fortunately, the HL Mencken filter was working. I didn't say everything that was going through my mind. But I limited my remarks that evening to congratulating the congressman and his staff, and that of Senator Leahy, along with the PTO director, David Kapos, who had remarked that how historic this legislation is because it was the first major reform of the patent law in almost 6 decades. And I did comment, and I'm sincere in this, that the passage of this act was a great example of how the system is supposed to work. Because you have the bipartisan effort in the legislative branch, you had the input and support of the executive branch, and they had the input from the judicial branch. But because of my Mencken filter, I did not say I thought the American people deserved a little better performance from their elected representative than just 2 laws in a whole year. And I say that because I had a strong desire that night to give my opinion to those the politicians that the art of compromise is considered and recognized by many folks as one of the characteristics that's associated with great statesmanship. And in my view, the word compromise is not a dirty word. And you, as lawyers and lawyers to be, but for your practice of the art of compromise, the economic engine of this country would come to a screeching halt. Now, I'm not just talking about compromising lawsuits, but just think about all the negotiation goes on in licensing agreement, all kinds of contract. But for that, I think it would stop. And I guess my strong feeling about compromise might relate to my training as a young lawyer. In 1968, I was practicing law in East Texas, and my mentor was a former judge. His name was Earl Sharp. I was on the opposite side of the case from him, but I had heard of his reputation, how he was the greatest, probably the best trial lawyer in East Texas at that time. And so anything he said, I just hung on every word, and he looked at me over that cup of coffee and said, "Young man, I'm going to tell you something that'll serve you well if you want to be a successful trial lawyer." Now, this was mentioned earlier, almost got it right this morning. Just remember that a poor settlement is better than a damn good lawsuit, regardless what side you're on. And so that sort of stuck with me. And over the next 20 years, I guess, I heard that not hundreds of times, probably thousands of times. And one of the things that, when I bring up Mr. Sharp, I have to tell you about a case I tried with him. It illustrates another point I want to make here today. I was working in Longview there, and it didn't work for Mr. Sharp, but our office on the same floor, and this was in October of '69. And to say that my situation with my employer was on the rocks would be a sort of a mild understatement. It was, you know. So Mr. Sharp asked if I'd go spend a day with him trying a lawsuit. He was glad to get me out of his sight. And so we go down to, Mr. Sharp had picked a jury down in Rusk, Texas, just a week before. And he gave me the file. It just consisted, as Tom Jackson knows, sometimes we had the files just be about that thick, a couple of depositions. And he said, "I want you to study this file and pick me up in the morning at 6:30. I said, "Yes, sir." So I read the pages off that deposition. It had the two depositions, it had a couple of exhibits in the file. So I go down and pick him up, and we drive. It's an hour-and-a-half drive. We go down there, and on the way, he says, "Now, I want you to put our driver on the stand. You think you can do that?" Oh, man, here is my opportunity in life. I'm really going to get this chance to impress this man. I was wound up, to say the least. So we get down there, and he said, "Now, you talk to the driver and make sure his testimony, make sure he's ready." And I said, "Oh, I will. What this was a no-contact collision case. Damages were stipulated of $50,000. Now, in 1969, that was a lot of money. Truck had swerved to keep from hitting someone and turned over, and they were suing the other driver because when I talked to him, I asked him what happened. He was he wasn't well educated. He was a bright guy. He said, "Oh, that car just set down the road, and I had to turn and go by it." And I said, "Oh, how fast were you going?" 55. "Well, what was the speed limit?" 60. So I get him on the stand. And I said, "Now, critical question, how far were you behind that truck this before I got him on the stand?" I said, "Now, how far were you behind that car when it just sat down in the road?" He said, "About 45 feet. Well, that's nothing at 55 miles an hour. That's what he'd said on his deposition, 45 feet. So I put him on the stand, and I was sort of, I was pretty enthusiastic, to say the least, and I don't want to go through the whole thing, but we got it down. I'd asked him these several questions, and I was going to really emphasize. Now, all right, now, Speed, your name's Speed. It's here on this birth certificate. That's not because you were a fast driver. Is that right? That's right. All right, now you're coming down Highway 69. It's a 4-lane highway, just a yellow stripe. Is that right? That's right. Okay, now I want you to, you're coming along, and that car just sat down on the road, and you had to swerve to miss it. Right. I said, now you tell this jury right now, how far were you behind that truck when it sat down in the road? I'm just doing that. I'm at this council table. I'm just like doing it right now. All of a sudden, Speed looked around. He said, about 200 yards. I felt that hot breath on my neck. And Mr. Sharp said, I told you to talk to him. I said, well, I did. Of course, I wanted to leave. I wanted to give up. It's over with. And so he said, well, he whispered, well, ask him what happened next. So I did. And he told what the truck turned over, and so passed the witness. And that lawyer on the other side is about the same experience level I was. He got up at that deposition, and he impeached him bad. He talked about, you testified to 45 feet. So mercifully, when they said, all right, redirect, the trial judge said, well, I believe we'll take our morning break. We took our morning break. Mr. Sharp looked at Speed and said, Speed, you could have turned around and went back to Jacksonville 200 yards. Why did you say that? Well, you know, Mr. John just got me so excited. Mr. Sharp got real calm. He said, now, Speed, how far did you go in school? He said, I just went to the 2nd grade. He said, do you know how many feet are in a yard? He said, no, sir. He said, well, do you know tell me how long a foot is? He said, oh, he knew exactly what a foot was. He said, all right, I want you to point out something in this courtroom that would sort of be about how far you were. Well, about from this side to that side. Well, in final argument, there were 46 one-foot square tiles on that floor, because I counted them in my opening. And with Mr. Sharp's brilliant argument, we won. And that night I got back in that car, and I started to Longview. Somehow they had moved Longview to Texarkana. Because when I tell you to prepare a witness, you prepare a witness. You go over his critical testimony 4 times, 5 times, whatever it takes. Don't you ever do that again. Yes, sir, Mr. Sharp. And let me tell you another thing. You should never get that excited. You get your witness excited, you don't know what he's going to say. You know, look what happened today. Yes, sir, Mr. Sharp. And another thing, I want you to remember, I could tell in your eyes, you was ready to give up. Yes, sir. He said, don't ever give up. He said, you know, trying a lawsuit's just like a boxing match. You get hit, you counterpunch. And another thing, just because you've got an inconsistency, you better think about how you're going to use it. So that lawyer gave you a break. You can't count on that. I said, yes, sir, Mr. Sharp. And then over and over again. And it seemed like it was a 4-hour trip. So the next morning I was in my office. Well, I should say this. I truly did not sleep a wink that night, because I've blown my one opportunity to impress the finest trial lawyer in East Texas. So the next morning, I was sitting there in my office, and Mr. Sharp stuck his head in. He walked in and sort of looking, and I said, good morning, sir. And he said, I got something I want to tell you. I said, yes, sir. He said, maybe I was a little rough on you last night, and I interrupted him. Mistake. He said, now just listen. I said, yes, sir. He said, I've trained a lot of young lawyers in my life. I said, yes, sir. He said, but I've always found that I actually had more success taming a raving maniac than I did resurrecting one from the dead. So you hang in there. And he turned around and walked off, and I can't tell you the excitement that some 10 months later, when he came back to see me, and we had a little firm of Ward and Ross, and he invited me to be his law partner. So there is always hope, in spite of some bad things that happen to you. Now, as Judge Everingham knows, that in April of 1973, that's 27 months after we formed our law partnership, we moved our office. And my wife that year gave me a hand-lettered poem. It was nicely framed by Theodore Roosevelt. And I guess she had some real insight based on her knowledge of me and what had happened. But I want to share that poem with you because it's provided some guidance. It still hangs on my wall today, some 39 years later. It is not the critic who counts, not the man who points out how the strong man stumbled, or where the doer of deeds could have done better, The credit belongs to the man who is actually in the arena, whose face is marred by dust and sweat and blood, who strives valiantly, who errs and comes short again and again, who knows the great enthusiasms, the great devotions, and spends himself in a worthy cause, who at the best knows in the end the triumph of high achievement, and who at the worst, if he fails, at least fails while daring greatly, so that his place shall never be with those cold and timid souls who know neither victory nor defeat. Now, Sissy had some real insight in getting this particular poem because, she had put me through law school, and here I was licensed on December the 4th, 1967, and prior to becoming a partner with Mr. Sharp in 1971, I had only changed jobs 6 times. So she knew of that night when I came home, and she knew of how bad things had gone, but she had seen how things went better. And that poem provided a lot of guidance. For instance, I won't tell the whole story, but she remembered that when one of my first uncontested divorce cases, I was out in Lubbock as an assistant county attorney, and we practiced law on the civil side because we had a salary of $435 a month. And I actually had a paying client who hired me to get a divorce for an employee who was there with a green card and spoke hardly any English. But it was great when he came in because the employer was there and translated everything. I failed, and this is your CLE for me, on always calendar events, put everything on the calendar so you're reminded, because I gave them a date to come back. I didn't put it on the calendar. I walk in, there's this poor fella. He spoke very little English, but his English was much better than my Spanish. And I got him up there to get him a divorce and work in head of somebody. And the judge had something else, and he was looking at that and obviously was thinking about the cases in front of him as opposed to this uncontested divorce. And when I said, "That's all we have to offer, Your Honor," and I had to raise my voice to get his attention, and he looked up, looked at my client, looked at me. He looked at who was sitting at counsel table, who he knew. It was Tom Richards, the assistant district attorney. He looked around, looked back down, looked at my client. "Stand up. Hereby revoke your probation and sentence you to 5 years in the penitentiary." True story. There's always hope, though, folks. All right, final thoughts. I got you. I got the lawyers here, so I always have to say this. And this is one of my serious observations. I believe, and I would like you to consider, that the glue that holds the fabric of our great country together is that we are a nation of laws and not of men. And it's our faithful adherence to the rule of law that has guided us from the birth of this fine, wonderful country to the place where we are today. In a very complex world, we're recognized as the superpower. So you as lawyers, and now as I'm practicing law again, I can say that about myself. We are the guardians of the rule of law and our system of justice. Judges cannot do it by themselves. They can never be better than the advocates who appear before them. And that burden is something we should gladly accept as we are allowed to practice our noble profession. So I say to you that there is always hope for a better and brighter future for our nation because of your participation in the justice system as advocates. So I hope you will do your job well. And finally, as you practice in this profession and deal with your adversary and you send those emails and you have those arguments negotiating, remember this. I want you to be always hopeful. I want you to plan carefully for the future. But do not forget the importance of civility and the practice of law. Because at the end of the day, you ought to be always mindful that you can leave this place without any notice. Thank you very much.
Some of those cell phones are really loud, Judge. I just wanted to thank you for that wonderful talk, Judge, and it has a lot to it. The Teddy Roosevelt quote is also a favorite quote of mine. Lamar Smith, you may be interested to know, is a graduate of this law school and spoke here earlier this year. So, I don't think he mentioned the two pieces of legislation. Maybe they can do better. But sometimes that's bad too, so, but in any case. Anyway, thank you very, very much for coming. It was a great honor to have you here.